Hello everyone. In the last presentation, we have seen that where certain circumstances like death, waiver, acquiescence, release, accord and satisfaction, obtaining a judgment, or limitation of rights are proved, the liability for tort would extinguish. We have seen the circumstances under which death of one of the parties would affect an action in tort. Let us now see how the remaining above mentioned circumstances would affect tortious liability. Waiver. Supposing the injured party has more than one remedies available to him and he elects to pursue one of them, he is deemed to have waived the other by election. Once he waives his right to the relief, he cannot revive it subsequently. Waiver may be express or implied, but it has to be voluntary. Here, the tort is not waived, but the remedy is waived. That is, though the tort is committed against the plaintiff gives up his right to sue for relief. When an act is both a tort and a breach of contract, the plaintiff cannot sue under both the heads, but has to choose between suing the defendant either for tort or for breach of contract, and when he makes a choice, he cannot go back on it. Whether the plaintiff waived his right or not is a question of fact and has to be decided based on the facts and circumstances of the case. Thus, where A hires a horse from B on express condition that it has to be used for riding only and not for jumping hurdles, A uses the horse for jumping the hurdles, during the course of which it falls and is injured badly, making it useless. Here, B can sue A either for a tort or for a breach of contract, and when once he elects it, he cannot go back on it. Acquiescence. Where a person knows that he has a right which is being infringed, but by his conduct before or after infringement causes the person who infringed the right to believe that he has given up the right, he is said to have acquiesced. This is associated with delay in bringing an action against the wrongdoer, but mere delay does not amount to acquiescence if there is a justifiable reason for the delay. Whether there is acquiescence by plaintiff or not is again a question of fact. Release. To release is to set free or give up. The plaintiff can release the tortfeasor, that is, the one who is responsible for tort, from liability to pay damages for the injury caused. But this has to be given in writing. If release is obtained by deceiving the plaintiff, or if the plaintiff is ignorant of his right, or because of some mistake of fact, he does not know that he has a right which is infringed, the release deed is not valid and the plaintiff will not be bound by it. Accord and satisfaction. Here, the release from tortious liability is purchased by the defendant from the plaintiff by providing some consideration. This agreement is the accord, and the valuable consideration is the satisfaction for arriving at the accord. Thus, accord and satisfaction will discharge the defendant from tortious liability. The satisfaction may be in the form of a promise to pay or do something when you call it executory, or it may be paid or done when it is said to be executed. Satisfaction can be made by a third party as an agent to the defendant. Where the accord and satisfaction is vitiated by fraud, it is not binding on the parties. If there is breach of accord and satisfaction, if the agreement specifies the mode of redressal for breach, that would be enforced. If the agreement of accord and satisfaction, which is a contract, substituted the tortious liability, the injured party can sue for breach of contract as per the terms of accord and satisfaction agreement. If the agreement of accord and satisfaction happens to be a contingent promise, which states that only if the consideration promised, that is, the satisfaction part of the agreement, is complied, the defendant would be released from tortious liability. And if it is broken, that is, not fulfilled, the plaintiff can go back and sue and claim damages in tort, or sue the defendant for breach of contract as the accord and satisfaction agreement had been breached. Judgment recovered. Where the competent court decides the dispute by delivering a judgment, the cause of action against the wrongdoer ceases to exist and puts an end to the right of action. When the judgment becomes final, that is, when an appeal against it is not preferred in the appellate court within the period of limitation, or where the appellate court finally resolved the dispute, the correctness or otherwise of the decision cannot be disputed. The injured party cannot bring another action against the wrongdoer in the same cause of action. According to Section 11 of the Civil Procedure Code, if a suit has been brought on the basis of a cause of action and decision is given, action cannot be brought again on the same cause of action. This principle is called the principle of res judicata. Limitation. The one who sleeps over his rights loses his remedies. Here, though the original right is not lost, the remedies accompanying the right will be lost, thereby making his original right incomplete, ineffective, and incapable of enforcement. For example, when A has right to property and B unlawfully occupies it, thereby infringing A's right to it. Here, if A does not bring an action against B for infringing his right of possession within the period of limitation prescribed under law, he would be barred from bringing an action against B. Period of limitation means the period of limitation prescribed for a suit or appeal by the schedule to the Limitation Act. And prescribed period means the period of limitation computed in accordance with the provisions of the Limitation Act. Where the breach of contract or tort is continuous, a fresh period of limitation begins to run at every moment of time during which the breach of contract or the tort, as the case may be, continues. Where nuisance is caused to the peaceful enjoyment of the property of A by unusually large amounts of smoke from B's property, so long as the smoke from B's property disturbs A, the tort of nuisance continues. Assignment of actions in tort. Now, can an action in tort be assigned to others? That is, supposing A injures B and B is entitled to sue A for tort of negligence. Here, can B assign the action to C? Let us say that C gives B some money and in return B assigns, that is, transfers his right to bring an action against A to C, and C is allowed to sue A for the tort committed against B. Is this possible or can it be done? The general rule is that such actions in tort cannot be assigned or transferred. This rule is based on public policy and is intended to stop trafficking in litigation. Exceptions to this rule under English law are death, bankruptcy, subrogation, that is stepping into the shoes of others, and judgment. These can be assigned, whereas the rest cannot. In India, mere right to sue cannot be transferred according to Section 6E of the Transfer of Property Act and under Section 61E of the Civil Procedure Code. However, a decree for damages before or after it is passed can be assigned. When goods are sold, the right to sue for injury done to the goods can be transferred or passed on from the seller to the purchaser of the goods. Similarly, an insurer who pays for loss suffered by the policyholder can file an action against the wrongdoer who was responsible for the loss caused to the policyholder. Now, this in brief is about the various circumstances which, when proved, would discharge the defendant from tortious liability. Thank you.